Hi, everyone. Well, I have an AirPod in my ear. I don't know why I have an AirPod in my ear. Welcome back to the channel, everybody. It's great to be here as always, and I'm here to tell you that there is an absolute melty going on right now in the mainstream corporate press. They are freaking out because in 1 week's time, there will be an oral arguments at the Supreme Court in the VanDerStok v. Garland case. That's the frame and receivers rule. And they're absolutely losing their crap over this. So that's what we're going to be talking about in today's video. After we hear a quick word from today's sponsor. Today's video is brought to you by 1st Phorm. 1st Phorm is a pro-American, pro-freedom supplement company. You probably eat way too much crap and not enough protein. So 1st Phorm's mission is to put more protein in your face hole. Now, the thing that I've been using a whole lot lately are their meat sticks. Now, these things are a 20 gram of protein stick. It doesn't need to be refrigerated. It doesn't have any like weird whey or any stuff like that. It is made out of meat. If you check them out using my link in the link tree or on the affiliates page, and that tells them that I sent you and that helps out the channel. So special thanks to 1st Phorm for making today's video possible. Now, sound off in the comment section down below if you would like to see me do a live stream on the oral arguments for you guys so that you'll have a reference either to watch live and discuss with me, or if you would like to just watch it afterwards from an unbiased source. Unbiased source. How about a source that doesn't have the usual biases that you have to filter through? How about that? I think that's a little bit more accurate. Definitely biased. But if you want to do that, if you want to be part of the discussion, have that hangout, then sound off in the comments, make that idea popular, and I will absolutely schedule that, and I'll put it up soon, actually. I'll just have it up there as a thing that we've scheduled and then we're going to do. Because those hangouts are a lot of fun, especially when you get to hear the difference between the people who are arguing for the righteous side and the people that are absolutely off their gourd arguing on behalf of the government. I have a process, and that is that I kind of every morning and night just kind of put things into the Google search and see what the mainstream outlets are talking about in the news as far as firearms are concerned. Well, I'm going to tell you right now, they are absolutely freaking out. And they do this thing where they kind of like carbon copy paste. They may change a word or two here or there, but basically all the articles are the same. And what they're saying right now is that they are very, very scared about the fact that this is up at the Supreme Court right now because they have no idea what's going to happen. Well, I'm going to tell you what is likely going to happen. And that is when you do something this outside of the bounds of the legal authority that has been granted to the executive agency by Congress, you have the potential to open a whole can of whoop ass on gun control. They should be scared. And the reason they should be scared is if we just look at an individual instance like the New York State Rifle and Pistol Association v. Bruin case, a case that was decided a couple years ago by the Supreme Court that has literally touched every single facet of firearms regulation in the United States. And if we look at that particular issue, if we're intellectually honest about it, substantively, it was a minor issue. Maybe not to the people who are living under it, but it wasn't a federal scheme. It was an individual state with a may issue carry permit scheme. And it was really one locale that really was the problem. And off of that, we have rewritten the whole standards test by which firearms regulation can occur in the United States to a state that I would say is reasonable when we're talking about analysis of whether something is constitutionally protected. And if it is constitutionally protected, when can regulations be applied to those individual conducts? When are they constitutionally permissible and when are they not? That is coming off of one issue out of one locale out of one state. What happens when you have the federal government overtly outstepping its bounds and spitting in the face of the intent and directive of Congress by taking one small statute that they wrote, taking a small part of it and running with it a mile? This is unacceptable behavior, and I'm here to tell you that the Second Amendment movement has changed. We are no longer beholden to some mega corporation that is going to decide what is a good fight and what is a not fight. No, we have smaller, more nimble organizations now that are literally just going to sue you into oblivion. Every small thing, every small inch that you try to take, we are going to fight you on it in hopes that we end up at the Supreme Court with a situation like this, which is blatantly outside the authority granted by Congress. So all of these articles look the same. They are all freaking out, and they are packed with lies. So I'm going to tell you some of the lies that they have packed in this thing, trying to scare people and freak them out and whip them up over what is likely going to be, at least I hope will be, if I've got the idea of how the Supreme Court would think on something like this and apply their own testing methodology, which is shaping up to be a major shellacking of gun control here very shortly. The first lie they tell you is they'll make up a definition for something called ghost guns. There is no ghost gun. It does not exist. There are two sort of working definitions that they use for this. This is something without a serial number, and they say that it can't be traced because it doesn't have a serial number. That is completely fictitious. That's not how that works. The only thing that a serial number does is track the chain of custody. It doesn't make the firearm unrecoverable. It doesn't make the firearm, there is no ballistics database. Like if they recover slugs or shell casings or something like that from a crime scene, that is not tied to a serial number anywhere. Right. So that's the first thing. The second definition that they use for the ghost guns is something that is undetectable by metal detectors. And that is simply does not exist. So both of these are fictions that they have made up. So that's the first lie. The second lie really integrates that kind of vague terminology there into this concept that these are sold as kits online that are fully functional. And that is not the truth. There is a statutory limit on what is considered a firearms part. So we have to make these things out of material. You have to get the material in at some shape, manner, or form. Okay, whether you're making it out of aluminum, we'll just use aluminum. It's got to come in as a block of aluminum that's a certain dimension so that you can complete the work out of it, right? So you can go on Amazon right now and buy blocks of aluminum. That should not be a regulated. You shouldn't have to have a federal firearms license to go buy a block of aluminum. Who knows what you're using it for? That's an unreasonable regulation. There is a point where you do enough to it that it is no longer just a block of aluminum, and it is now a firearms part that it requires a license to manufacture and sell and transfer and all that sort of stuff, right? There is a current defined point. Where that line blurs is there's a lot of 3D printing technology out there, and what they will tell you, my phone, not yours. Sorry, that was an important phone call that I had to take. But what they will tell you is that these are finished parts with an arbitrary amount of tooling that has to be done to them to make them operational. And that is outright a lie, which brings me up to the third lie, which is they say that this process can be completed in a number of minutes. Oftentimes 20 minutes is cited. And I can tell you, as someone who has completed multiple of these and has failed to complete multiple of them, as in I completed them and they didn't frickin' work afterwards, that is an absolute misrepresentation. The only person who has completed an 80% whatever and 20 minutes or less is someone who has gone out and has a six-figure CNC milling machine and an employee that they pay $80,000 to $100,000 a year that can program it and turn out those parts. That is absolutely divorced from reality. And this is really easy to prove. If you have completed one of these things or have seen someone or know someone who has completed one of these things, then sound off in the comments down below and let everybody know, how long did it take you to get it done or your friend to get it done? And two, did it work? How many tries did it take you to get it to work? And was it as great as if you just went through the process, right? Those things in the comments section down below, which brings me up to the fourth lie, which is that this somehow circumvents the law. It has always been legal for United States citizens to manufacture their own weapons. It has been legal for citizens of the United States to manufacture their weapons for themselves before the United States was the United States. It was legal for you to manufacture your own weapons under British rule. The only impetus that the government has to inject itself into whether you can manufacture a weapon is under the Commerce Clause. That's the whole basis by which the ATF exists and exerts its authority, is interstate commerce. If there is no interstate commerce, then they do not have anything to do with it. So if you were to go in your backyard, to be super simplistic, and cut down a tree and make a receiver out of that tree, they have nothing to do with that whatsoever. So if there's not a business-to-business interaction, then there is no interstate commerce, and they do not have the ability to regulate that under the law. So it is not illegal to do this sort of thing. And then the fifth lie that we're going to cover here today, which is the most egregious, is that these are predominantly used by people, and I want to get the quote right because this is copy and pasted consistently, disproportionately used to commit murder, domestic abuse, and terrorism. There are tens of millions of these things out there in circulation. If there were tens of millions of problems out there, you would know about it. That is not what's going on. Most of these are held by peaceable citizens that aren't doing anything illicit or anything like that. And I guess to wrap up today, the reason that they are freaked out, the reason they are having a melty over this is because they know that they overdid it. Before the Supreme Court right now is the question, where does this fit in the intent of the founders from around the time of the ratification of the Second Amendment? Where in the text, history, and tradition of firearms regulation in the United States does this sort of activity by the federal government fit? And I'm going to tell you that you're going to find it pretty thin on the historical context right there. So every single time you do something like this, we now in the firearms space see this as an opportunity to take you to the mat. And we're going to do everything in our power in front of the Supreme Court, read the briefs, to gut as much backlog of perpetrations against the Constitution that you guys have been able to get away with for decades. And I'm excited to see what comes out of this one. Sound off in the comment section down below. That's all I got for you guys. Let me know what you guys think about what I have covered here today. What do you expect to come out of this whole thing with the VanDerStok v. Garland case? Bye.